So we're here to discuss something really, really important, and we need to agree on one thing first, and that is we are all going to die. Some of us sooner than others, and we never know when God's going to come down and go, it's time to come home.
You never know.
You never know. But today we want to talk about what you can do or what estate planning options you have with your not only real estate, but your overall estate, your jewelry, your IRAs, all of your assets, and what can happen under the different scenarios. So let's start by you giving the disclaimer.
Yeah,
Okay?
disclaimer, we are not attorneys, we are not tax accountants, and so obviously seek professional advice from the
qualified
professionals. But we wanted to talk about this today because a lot of our clients deal with, settling estates and loved ones passing away, and basically handling the aftermath of oftentimes properties that are being inherited or passed down.
Or the aftermath of poor planning.
Yes,
right? Poor
absolutely.
planning or no plan. And we're going to have just a free-flowing conversation today in general areas, and we're going to talk first about having what I call pre-death management of your estate. And that's where you give your assets away while you're alive. Mm-hmm. So while you're alive, if you want your assets to go somewhere, you give them away, right? Make sure that person that you want to have them has them. It's in their name. This could involve assigning LLCs for businesses. It could be deeding properties to heirs while you're alive. And we're going to talk a bit about the problems we've seen with that. Yeah. But Lehua, what do you think the biggest challenge of doing this kind of estate planning is?
I would say the biggest sort of issue that comes up from that is for the heirs. It affects the heirs the most because there are often increased tax repercussions once the person who's gifting the property actually passes. It can, if it's an investment property, it can affect your basis negatively.
Well, it affects all properties.
Yeah, all properties. Yeah. But yeah, it has, it definitely is sort of a financial hit to the heirs.
And so let me give you an example. I have a client that we're working something out right now on. Property was bought by the family at about $5,000.
Wow.
It's now worth around $900,000. And they did have an estate plan, but it wasn't well done, and it's a mess. Let's just call that.
Yeah.
I helped that same client with another property in the same area, and their family did what a lot of local families do. Mm-hmm. Oh, well, let's give it to our daughter, to our son while we're alive, and then, or they make the son or daughter joint tenants so that when they die, they get the property.
Yeah.
The challenge with that is there's something called stepped up basis. So the $5,000 is the current, or is the basis mom and dad paid for it, or grandma and grandpa in this instance.
Yeah.
And stepped up basis is the value when they die. There are other videos that we've done here, but the differential would have been if it was willed or went through a trust to the family after the death, instead of paying taxes on $895,000 in value, the family would pay taxes on everything that was above $900,000. So that's about a $270,000 tax swing.
Yeah.
So the gifting or giving it people property while you're alive can create tax problems for your family down the road.
It can also sometimes force heirs into the position of needing to sell the property when they're hit with a large tax burden like that, when otherwise maybe they could have held on to it longer as an investment and probably cash flowed from it. So yeah, something to keep in mind if you are thinking about gifting or deeding a property to someone that you like while you're alive.
While you're alive.
Yeah.
We'll come back to that in a bit.
Yeah.
One of the benefits of pre-death management is what we're calling it, or pre-death estate planning, is that it's not public.
Yeah.
Right? Nobody knows what you've done. Nobody will know. They'll be able to guess, but nobody will know. And that's some of the challenges with a couple of the other ways of doing it coming up.
Yeah.
Right? But don't recommend pre-death management because it just can put your heirs in a bad position. Let's jump into no plan.
Well, actually, there is a plan if you don't make a plan. So if you choose not to make your own will or make an estate or make a trust or basically make a plan for everything you own before you die, the government already has a plan for you.
You have a plan.
And it's their generic template. And basically, they will go down the list of your survivors, essentially. Do you have children? If you don't have children, do you have surviving parents? Do you have surviving siblings? Do you have surviving aunts, uncles, cousins? Or even before that, do you have a surviving estranged spouse or something? You know what I mean? So there are all sorts of
that estranged spouse who has tortured you your whole life could end up with your whole estate.
Yeah. So something to think about. There is a plan for you that's been laid out by the government if you choose not to set your own plan in place. Right.
And so let's talk about some of the things with it. It's likely going to be public record because it has to go through the courts, right? It's going to be expensive because somebody has to hire an attorney to get a personal representative appointed, and the court has to appoint it. A motion to approve the representative is filed, and an order is filed.
And it takes a long time.
Takes a long time, for sure. So let's look at our notes. How much time could it take?
Well, it can take 4 to 6 months for a personal representative to be appointed, and then the process can really begin. So, you know, can it take a year?
Easily.
Yeah, easily. Could it take a couple years? Yes.
Easily. I'm working on one right now that I think they've been working on it 5 years.
Yeah.
So
unfortunately.
But here's what it is. First of all, it's going to be expensive. Second of all, it could get more expensive because if you haven't made your wishes known, then let's say we're two siblings and we're at odds with each other since we're in the 5th grade. You die, and now there's no will available to tell people what your wishes were. I lawyer up, Lehua lawyers up, and we're fighting over who the personal representative is, what percentage she's supposed to get of what property. Assets, we just talked about offline, about IRAs, different investments, what's going to happen with those assets. And once everybody lawyers up, the old saying, only the lawyers win, can be true.
It can.
So just to put a bow on this, it can be a mess, and your mess could be of public record and available for everyone to see.
Yeah.
Okay?
Yeah, so
let's go through our next layer. This is where you get a will only. Okay? And why don't I start on this one? Sure. You may need court approval of things. If your heirs are not in agreement, you may need the court to approve certain aspects of the estate. It will be a public record because your will is filed in the public records. It can take 60 to 90 days to get into court to approve a sale or a transfer or anything if you need court approvals. It doesn't have to take that long.
Right. And you can't close on the sale of the property until 30 days after you get court approval. And
that's the court order signed.
Yeah.
And sometimes the court can take 30 to 60 days to sign it. And then the 30-day clock starts running.
Right.
So sometimes that can hurt your market value too, because if you're looking at a 6-month process,
Mm-hmm.
sometimes buyers aren't willing to hang out that long.
Right.
Yep.
Right.
So let me talk about, there's another thing. So if you have to go to court, it can be a mess.
Mm-hmm.
One way to avoid that, see your attorney about this and what they say. If the heirs will sign what we call consent letters, then you can avoid a lot of that.
Yeah, sometimes
With
that
your
helps.
attorney's advice.
Yes,
Right?
with
your attorney's advice.
of course, yeah.
But it doesn't have to take that long, but it will take longer than a trust,
Mm-hmm.
for
Yeah.
sure. And again, the biggest thing is that your estate becomes public record.
Yeah.
And
that can expose a lot. I mean, sometimes people have children that they have not told their family about,
Yep.
that they have willed assets to, and it's all
Yeah.
made public.
So two fun stories. I'm going to leave names out to protect the innocent, but I'm aware of a situation where pretty significant estate was being settled, and they went in for the settlement, and there was an extra person there. And true story, that person was an illegitimate child that the deceased had made concessions for via the trust. So this is, we're going to talk about trusts.
Yeah.
The benefits of a trust is the world didn't know about it. Also, if it were a will, that would be public knowledge,
Mm-hmm.
right? Or if the illegitimate child via I'm not an expert on this, but I don't believe they would have much standing in the intestate. Intestate is dying without a will, right?
Right.
They may or may not be able to. They'd have to enforce their claim. So if you're in that position and you want them taken care of, you want to get a will or a trust. That's my 2 cents. I'm also aware of a situation where there was a girlfriend that nobody knew about, but via the trust, how should I say, arrangements were made for parts of the estate to be distributed to the girlfriend.
To the friend of many years.
Yeah, the friend of many years. Yeah. So
Yeah.
The nice thing about a trust is that it's not public. So
Mm-hmm.
let's why don't we jump into the trust?
If discretion is important to you, consider a trust.
Yep. And so a trustee is appointed,
Mm-hmm.
right?
Yes.
And the trustee has the power to sell,
Mm-hmm.
has the power to act without court approval. All right.
And it's the fastest way to sell a property when somebody passes away.
When somebody's passed away, the main thing that slows up trusts in Hawaii are death certificates.
Right. Which that can take 4 to 6 weeks, or if the death occurred in if it was not kind of like a normal peaceful death, then sometimes it can take a couple months, or up to 6 months if something really crazy happened.
Okay.
But typically it's more like a month,
Okay.
a month and a half.
Versus if you look at how that compares to a will, it's probably 6 months, every bit of 6 months
Right.
to close a property via a will. And so in all these instances, right, with the exception of the pre-death management,
Right.
in all these instances, if you're a PR, if you're a trustee, if you're the person settling the estate,
Mm-hmm.
it's recommended that you not distribute money to any of the heirs until the estate is settled and the tax return is filed.
Yeah.
Because you don't want to give the money away and find out that you have taxes to pay that you now don't have the money for.
Right.
Right?
Right.
So highly recommend that you seek legal advice for your life. Let's call it your life,
Mm-hmm.
Especially if you own real estate. But I think you need an estate plan even if you don't own real estate.
Yeah.
It's a complicated world.
Definitely. But
Yeah.
especially if you own property,
Yeah.
It's absolutely worth putting the thought in advance to the best solutions for you and your family. If you need any contacts of good estate
Yeah.
planning attorneys in Hawaii, we work with a few regularly, and would
A
be
lot of
happy to a lot
Yeah.
of them
Yeah.
would be happy to connect you with someone good. And yeah, we just wanted to sort of touch on this subject because it's an important consideration for us, for our clients, really for everybody, and good to think about and plan ahead. So
Yes. Do your family a favor, think ahead, do the hard work, and make hard decisions for them before you die.
yes.
Because
we're all gonna die.
yes, we are. Woo-hoo! Well, look, thanks for watching.
Yeah.
And say goodbye.
Bye.
Bye. We'll talk to you on our next
Yes.
video.
Thanks for joining us.
Thanks for coming.
Shoot.